Guys, welcome back.
Thank you for having us.
Great to have you both. All right, so the jury wanted to have read back, oh yes, the jury instructions. We all know why. They didn't understand anything because New York State doesn't allow the jurors to take the jury instructions back into the room with them. So it's, my God, this is so confusing. It's not like, did he sell pot or didn't he, right? It's like, good Lord, they have so many steps to go through. So they did that. And then they wanted to hear read back certain portions of the testimony. And I definitely want to hear your thoughts on what we can glean from what they wanted. They wanted certain sections of David Pecker's testimony, the guy who was running AMI, the National Enquirer, and they wanted a little bit of Michael Cohen's testimony as relates to one meeting he allegedly had with David Pecker. They're definitely interested in David Pecker. And my note to myself reads, could the AMI payment to Karen McDougal carry the day? Like that was my takeaway, having read the portions that they wanted to hear. And this is where it got me. This jury may not be putting as much weight on Stormy Daniels as the rest of us did. They may be going with the theory that was argued quite a bit by the prosecutor in his closing, which did spend a lot of time on Karen McDougal, the catch and kill scheme, that was the word used. And like the whole thing, they try, even though we've all been focused on Stormy, the prosecution did argue that the whole thing with AMI was part of this alleged illegal scheme, even though Pecker's done it for many other politicians, including Democrat Rahm Emanuel. But okay. And they wanted to hear Pecker's testimony as follows, that Donald Trump acknowledged, this is David Pecker telling the jurors, this is what they had read back to them in part. Donald Trump acknowledged to me that he had spoken to Michael Cohen and acknowledged to me that he knew Karen McDougal and said, she's a nice girl. All right, so this was Pecker sort of saying, I recognize the story about Karen McDougal allegedly having a year-long affair with Trump was probably true, because his response when asked was, she's a nice girl. David Pecker, let's say that he testified that Donald Trump, he recommended that Donald Trump buy Karen McDougal's story, and that Michael Cohen called David Pecker back and told Pecker, go ahead and do it, buy it. And that this was on behalf of Donald Trump. This is what David Pecker said he understood. He testified again that he believed the McDougal story and that he thought it would embarrass Donald Trump and hurt his campaign, both. And he recommended that they buy it, and then Cohen called him back and said, do it. Go ahead and do it. And that he understood that was Trump's okay. Then David Pecker said the reason I bought the negative stories on Trump was to avoid personal embarrassment to him and to help his campaign. On cross-examination, they tried to bring out that his memory wasn't perfect, that these events happened a long time ago. And they got into, overall, this is still direct, David Pecker decided that he did not want to be repaid for Karen McDougal's story after he paid her $150,000 for it. And this is something I missed first time around, guys. There was a reason he didn't want to be repaid. It's not that David Pecker had unlimited funds to spend for Donald Trump. It's that he started to get scared that he was going to be in trouble for making an illegal campaign donation. And there was testimony to that effect, that in David Pecker's mind, he had some worries after consulting with a lawyer about seeking reimbursement. He thought it would be too on the nose, and it would underscore that this really was a deal to reimburse him for something, a contribution he made to Trump, and that he just decided to eat it. Now, that doesn't put that knowledge in Donald Trump's mind, that, holy shit, we might be violating election law, which is what they need to do. The prosecution needs to get in Donald Trump's head. We're violating the law right now with this agreement. They haven't done that, but there is testimony by Pecker that he had concerns, and I'll just give you some of it here. Question by the prosecutor: did you come to appreciate the legalities surrounding such an arrangement with a political candidate? Answer: yes. That was the first time I ever came across a political contribution, what a violation was. Objection sustained. He asked again, well, what did you in your mind take away from that experience that you had as a result of the Arnold Schwarzenegger situation? And he said, based on what happened 14 years ago, meaning with Schwarzenegger, I wanted it, meaning with Trump, to be comfortable that the agreement we were going to prepare for Karen McDougal met all the obligations with respect to a campaign contribution. Did there come a time when someone at AMI consulted with an election law attorney? Yes. I called Michael Cohen. I told him that we finalized the agreement with Karen McDougal, that the contract was bulletproof, and we consulted with a campaign attorney. Question, and to your knowledge, what did the campaign attorney review? Answer, the agreement, meaning the contract, yes. And then just a little bit more. Were you aware that expenditures by corporations made for the purpose of influencing an election, made in coordination with or at the request of a candidate or a campaign, are unlawful? Answer, yes. Question, did either you or AMI ever report to the Federal Election Commission in 2016 that AMI had made a $150,000 payment to Karen McDougal? Answer, no, we did not. Why did AMI make this purchase of Karen McDougal's story? We purchased the story so it wouldn't be published by any other organization. And why did you not want it to be published by any other org? We didn't want the story to embarrass Mr. Trump or embarrass or hurt the campaign. When you say we, who's we? Myself and Mr. Cohen. But for Mr. Cohen's promise to reimburse, withdrawn. But for Mr. Cohen's promise that Mr. Trump would reimburse AMI, would you have entered into this agreement? No. Did you have any discussions with anyone in the Trump camp about Donald Trump reimbursing AMI for the money paid to Karen? I did. I had conversations with Michael Cohen. All right. So that's a long lead up to you guys. That seems to be what the jury's interested in this morning. Dave, what's your take on it?
Well, good to be back with you, Megyn. First time back since your Bill Maher interview, which I thought was riveting, by the way. Well
thank
done.
You.
Yeah, I love how you have diverse viewpoints on, like mine. And good to be back with Mike. I do think the questions are good for the prosecution because, as you set forth, they are framed in the prosecution's narrative, their story of the case, their theory of the case, rather than the defense's. If they had asked questions about Michael Cohen's credibility and about that controversial phone call where the 14-year-old was trolling him, then I think that would benefit the defense. But these are questions to buttress the prosecution's story, and it looks like they may have a couple of holdouts, and this is a way of trying to get them to go along. But yeah, you're right that the phone call with Pecker while he was at the investor meeting is really important because that's where the prosecutor said that Trump deputized Cohen right in front of Pecker so that Pecker knows that any go-ahead from Cohen is a go-ahead from Trump. That ties Trump directly to the scheme. So it makes it impossible for the defense to claim that Cohen was acting on his own. And I think it's important that when Pecker spoke about this, he talked 3 times about this call while he was on the stand. And he said that he told Trump that I still think you should buy the Karen McDougal story. And then Trump said to me, this is according to Pecker, I'll speak to Michael and he'll get back to you. So I think that's really important. And then you're right about Pecker and the $125,000 rather than $150,000. That was a blow up with Michael Cohen, that Pecker decided to back out of the deal where they were going to assign Karen McDougal's life rights back to Michael Cohen and Donald Trump in exchange for $125,000. And when Pecker backed out of the deal, he said that Cohen blew up and said the boss is going to be really upset about this. So this is all a way to tie Trump directly to the scheme itself. So I think this is good for the prosecution.
What do you think, Mike? They're very interested in the catch and kill scheme from the sound of it.
Yeah, they're very interested in that, but guess what? That's not a crime. It is not a crime to run a catch and kill scheme. It's not a crime to settle a nuisance claim. There's not a crime here, and that's the problem with this entire prosecution. They did not explain to President Trump, the criminal defendants, throughout the entirety of his criminal trial, what the legal allegations were against him. They did not explain those legal allegations until the very end. And then this Judge Merchan, this corrupt Judge Merchan, who made an illegal campaign contribution to Biden that got him reprimanded from the New York court system, we found out several months ago. This judge's daughter is raising millions of dollars off of this case. This judge did not explain to the jury what the legal allegations are until the very end. And then these legal allegations are you can pick one thing, you can pick another thing, or you can pick another thing. You don't have to be unanimous. And that's the problem with this whole trial. It is fundamentally unconstitutional. It's fundamentally unfair against President Trump, and they don't care. I mean, the fact that the jurors are asking this question, it shows you that they're not being guided by the law. This judge has not done his job in instructing the jurors on what the law is and what is actually relevant, and what facts actually matter.
What's interesting to me is that there might be some disagreement at all. Like, you could have thought that a New York jury would go back there and say, well, I think he's guilty. Does anyone disagree? And everybody's like, nope, I agree. And they could have come right back out with a guilty. So there's a smidgen of hope in here for Trump, in that they wanted to hear the instructions back. They wanted to hear testimony read back. They're definitely struggling with, has the prosecution met all the elements, and what is the proof that will get us there? It's not at least been a knee-jerk, he's guilty, right? Everyone agree, right? If you watch Dateline as much as I do, you know that does happen in the most persuasive cases. It doesn't take the jury very long. I'm sure you guys have had trials like that where it's really not too tough and the jury comes right back. This at least is not that, Dave. And yet, when you hear the actual substance of what they want to hear back, it does sound more pro-prosecution than pro-defense. But there's also the possibility that they wanted all this focus on Pecker's testimony because he was witness number one. Maybe they're just going through it chronologically.
Very true. And reading the tea leaves is often a fool's errand. And so we're doing the best we can. But yes, you're absolutely right. That could be the case. There are reports that there is at least one juror who is very sympathetic to Trump, who was smiling when J.D. Vance walked in the room, the senator from Ohio, and was very pleased when other Republicans entered the courtroom. So that could be a holdout juror, and we just don't know. Now, one thing that New York needs to change, aside from allowing cameras in the courtroom, please, is also to allow the jury instructions to go into the deliberation room with the jurors. Why make it so much harder? Why slow things down? Why play hide the ball? So New York has some changes that they're going to have to make as a result of this trial.
Haven't we been on this show for a year now trying to figure out what the hell this case is about? And these 12 lay people, Mike, are supposed to go in there and, like, after hearing the jury instructions now twice, magically have a complete run of it. I know. Oh, yeah, exactly. No, yeah. Well, we don't have to be unanimous on the underlying crime that he allegedly committed or tried to conceal, but we do have to be unanimous on the final verdict. So is everybody clear? Okay, and raise your hand if you think he violated federal election laws, the underlying crime. Raise your hand if you think it was more document falsification. You over there, who did you vote for tax fraud? Yeah, that was tax fraud, right? So we've got 3, we got 4, we got another 3, but how are we unanimous on the ultimate? I mean, can you imagine what's going on in there?
And that is a clearly unconstitutional legal instruction that Judge Merchan gave to the jury, where he instructed the jury that they don't have to be unanimous on whatever the second crime or second bad act that Trump supposedly committed in furtherance of this underlying bookkeeping misdemeanor that transformed this underlying bookkeeping misdemeanor. It's not a bookkeeping misdemeanor because a legal expense is a legal expense and it's in his private books. So how can this be a business bookkeeping misdemeanor? But let's play along. They don't even have these jurors were told by Judge Merchan they don't even have to be unanimous on what the second crime was to make this bookkeeping misdemeanor 34 felonies. That is a direct violation of a Supreme Court case that my former boss, Justice Neil Gorsuch, wrote in 2020, Ramos versus Louisiana. You have to have a unanimous jury verdict on all essential elements, and that applies to federal cases and state cases like this case in New York. This is clearly unconstitutional. And if New York statute says otherwise, that New York statute is unconstitutional. And if this judge were actually doing his job, he would have read that New York statute so it was in line with the U.S. Constitution. So it was in line with Ramos versus Louisiana from 2020. But he didn't do that because he is a corrupt partisan judge who is railroading President Trump because his daughter is raising millions of dollars off of this case.
Megyn, can I jump in on that?
Yeah.
Thank you. I know there's been a lot of talk about how you don't have to be unanimous, but I reread the jury instructions, and you do. Number one, you have to be unanimous on the falsification of business records. Second, this according to the jury instructions, it says the jury must find unanimously that Trump intended to defraud by concealing a conspiracy to promote his election as president by unlawful means. That's that second statute, the one we discussed, the New York State law. Yep. You have to be unanimous on that.
Not on what he was trying to cover up, the crime he was trying to cover up.
Well, it's on the unlawful means. What is unlawful means, right? Within that state statute, what is unlawful means? And you could have different interpretations of what unlawful means, meaning it could be the campaign finance, it could be tax issues, it could be the subsequent falsification of records by Cohen when he applied for the loan from the bank.
Dave,
those would be unlawful means.
You don't find this unfair to be like, I said yesterday, it's like, let's make a deal. In door number 1, you have federal election violations. Who would like to choose that as your underlying crime? On door number 2, you've got additional business records falsification. Who would like to sign on to that? And door number 3, the little known and beloved tax fraud, in which absolutely no one was hurt and New York State got paid more than it otherwise would have. Can I see a show of hands? What kind of due process is that to a defendant?
Well, the initial statute, remember, the underlying statute is falsification, has to be unanimous. Then it has to lead to concealing another statute. That, too, has to be unanimous. And that's why, to me, it satisfies due process. The part that doesn't have to be unanimous is not an element of the crime. It's what are the unlawful means within the second statute.
Unlawful means is an element of the crime. You don't have unlawful means unless they find that he was either committing or concealing one of those 3 things.
Well, that's going to be on appeal, whether it's interpreted as an element of the crime or a manner in which the crime was accomplished. And that's why, to me, it seems to satisfy due process. I think the bigger challenge...
Let me ask you a follow-up on that. Okay, a follow-up.
Sure.
Because Andy McCarthy's been writing for a couple months now about something he broke on this show, which is that it's so confusing to my audience members. I know you're hanging on by your fingernails. We all are. But just go with me. The first crime is falsification of business records. That's the misdemeanor that got elevated because he allegedly did it for unlawful means. And that unlawful means part is a New York State law that says you can't conspire to win an election by unlawful means. And we used the example yesterday, like, okay, if you steal ballots out of somebody's box, mailbox, yeah, I got it. That could potentially violate that New York State statute. But what Andy's been pointing out is that there's a New York State constitutional provision that says you cannot incorporate by reference when making something unlawful. You have to say specifically what law they're not allowed to violate. In other words, that law that's right on layer 2 there, right? Falsification of business records was a misdemeanor, but it goes up to a felony if it's to campaign by unlawful means. And that law right there is not going to be upheld on appeal, Dave, because you can't just say unlawful means. Let's make a deal. That's what led to the let's make a deal. And Andy's been making the point that law is going to be struck down under New York's Constitution. Forget due process in our federal Constitution, which is also at play.
It is a real possibility. My friend Eric Columbus, who is a progressive legal expert, said that he expects there to be a conviction, no jail time, and the conviction would be overturned on appeal. And I think if it is overturned on appeal, it would be because of that. But it is a legitimate debate whether that unlawful means is a manner in which the crime is accomplished or an element of the crime. Because remember, it's the 2 words within that secondary statute, and that statute still has to be proven beyond a reasonable doubt by a unanimous jury. It's just up to the jury to determine what are the unlawful means. Is it the tax issue? Is it the campaign finance issue under federal law? Or is it the falsification of business documents that Michael Cohen did to get the loan from the bank?
So where was the legal expert, Mike Davis, on New York State or federal tax law? Where did I miss that testimony? Where was the election law expert, Brad Smith, to actually help illuminate this is what would be illegal? Where was that? Because I'm going to venture to guess these jurors don't understand what rises to the level of illegality under the tax laws, under the election laws, or the business records laws, the 3 possibilities in front of those doors, any more than any other layperson walking around out there in New York does?
That's a very good question, because this corrupt, biased Democrat Biden donor judge, Juan Merchan, refused to allow President Trump to call Brad Smith, the former chairman of the Federal Election Commission, as an expert in federal election law. And this judge is saying it's my job as the judge to instruct the jurors on what the law is. Well, he didn't do that. And he actually let Michael Cohen and even David Pecker testify as to what this election law is, which is, I don't know how that's not reversible error in itself, but this jury is left utterly confused as lay people. I guess there are two lawyers on this jury, but we have this jury that's utterly confused as to what election law is. This judge will not give them the jury instructions on paper so they can look at this and try to make sense of it. And here we are, three lawyers on your show right now. I mean, I think that you two are much smarter than I am, but we have reasonable intelligence between the three of us. And we don't know what the hell the legal allegations are in this case after the trial's over.
I know. That's what's so scary. Think about it, Dave. You prosecute cases for a living, and we're still like, well, this part may or may not be constitutional. Well, this seems to be making a reference over here. And federal election law, I mean, for the record, this is what happened. The defense wanted to call Brad Smith to offer testimony on federal election law, which the feds have specifically said needs to be handled by the Federal Election Commission because it's so complex. It should not be a law that's enforced by any rope-a-dope prosecutor like Alvin Bragg. That's why they gave them the exclusive jurisdiction over these claims. But Bragg backdoored it into the case. And then when Trump said, well, somebody should hear from an expert on what that statute actually requires and doesn't, the judge said no. Finally, he said, you could put Brad Smith on the stand to define like a couple of terms. And that's it. And Trump's like, oh, forget that. And Brad Smith tweeted on X. He's so limited what I could say that it became pointless, and the defense decided not to call me. So for those saying like Trump decided not to call him, that's not what happened. He got limited such that Brad Smith's testimony would have been irrelevant. But you guys and I have been round and round on Brad Smith, Dave. We just played that famous soundbite that we had yesterday when you were on with Arthur, and Arthur was here yesterday, and Brad Smith was here, and he was explaining federal election law, and you asked him about the John Edwards case, and he had a good answer for you on it. And I actually, in my spare time, because I have no real life, was watching old C-SPAN clips of Brad Smith. I need help. I hope sometime I get the help I so desperately need. Anyway, he was even more interesting, believe it or not, on C-SPAN, right after Michael Cohen got arrested. And even then, he was like, I don't think they've got him on federal election claims. And he went on there about why. So we cut a decent soundbite of that. Let's take a listen. I think it's, Kelly, I think it's soundbite 9. Yeah, it's at 9.
I'm skeptical, though, I will tell you, John, that this is a violation of campaign finance laws for a couple of reasons. First, the law has long wrestled with this idea of anything that's for the purpose of influencing a campaign. That could be anything. That could be hosting a 4th of July party in your backyard, right? And so the law has always said we need to narrow that down. And there are a number of exceptions. Some are in the statute and some have been created by courts as a constitutional matter. But the one that's of interest to me here is there is an exception for what is called personal use. That is, you can't use campaign funds for personal use, even if it might be being done to benefit your campaign. Let me give a couple examples. If you were to say as a candidate, boy, I'd look great in that debate next week if I had that nice new suit, right? Can you use your campaign funds to buy that suit? No. Even if you're honestly thinking that'll make you look better in the campaign debate the following week. Can you say, I at the end of a hard day of campaigning and to be ready for the next day, I need a good massage. Can you use campaign funds? No.
And then I'll just continue it. Here he goes on in SOT 10.
And I think it's a common sense matter. If I were to ask people 3 years ago before there was Donald Trump, I said, look, do you think paying hush money to quiet charges of sexual harassment or somebody who's trying to get hush money for an affair you had, do you think that's a legitimate campaign expense? I think almost everybody would say, no, you can't use campaign funds for that. That's not what campaign funds are for. And I think that's the way the law is, in fact, written, the law says very clearly that the obligation has to have been created by the campaign. Again, a dalliance you had years before created the obligation. That's not a campaign expenditure.
The obligation has to be created by the campaign. And he said to us, it's not a subjective evaluation. It's an objective evaluation on what is the nature of this payment and is it one that could ever be used outside of the campaign context. So polling, yes, the campaign expenditure. Get out the vote materials, yes, campaign expenditure. But hush money to pay off somebody threatening to embarrass you in the media, definitely not. People do that all the time, as David Pecker testified, but this jury definitely does not understand that, Dave.
Well, I point to John Edwards again, and there was a prosecution, not a successful one, but the feds brought it because donors paid his mistress to keep her quiet. Now, his case was stronger than Trump's because they paid her well in advance, and they kept paying her well after the election. Here, there's plenty of evidence that Trump wanted to pay off Stormy Daniels to keep her quiet before the election and didn't even want to pay her, wanted to delay the payment until after the election so he wouldn't have to pay her at all. So I think
you're getting into motive. You're getting into motive, which I get. You're right in line with the judge's instructions in doing so. I mean, I get it. And that this is what the jury is going to be debating right now behind closed doors. But and you raised John Edwards with him, and he shot that down, saying that they got it wrong. That was not an appropriate reference to the campaign laws back then. And sometimes judges and juries and even prosecutors, they get it wrong too. And two wrongs don't make a right is basically what he's saying. And here we have, it's like the underlying basis for it's like think about the norms they've crossed. Mike, I'll give this one to you. It's not even like, oh my God, this is such an egregious violation of the election laws, we've got to do it. And it's the feds who have the jurisdiction. This is a state prosecutor without jurisdiction who's gotten this in front of this jury, backdoor, because first thing is falsification of business records. Then you add the unlawful means to make it into a felony. Then you got to ask what unlawful means are. And he's got the three doors, right? Federal election law, tax law, and additional business record falsification. And it's only down there that he tries to resurrect this claim in a way that they did in the John Edwards case, which wasn't one and which has been criticized by people who understand the law, like Brad Smith, who got the boot on the forehead when he tried to get in front of this judge and jury.
Well, first of all, we have to clarify this. Did John Edwards use campaign funds to pay his mistress, or did he use personal funds? I just don't know that. And
it was
makes
Bunny
a big
Mellon
difference.
paying off Riel Hunter. My God, where's that? Look at those names. They're still in there. The hamster's still running on the wheel.
Well, anyway, so I would say this. There is a reason that the prior Manhattan DA, Cy Vance, a Democrat, the Manhattan U.S. Attorney, the Federal Election Commission, and Alvin Bragg himself, even though he campaigned on getting Trump, there is a reason they passed over this bogus, partisan, corrupt legal theory. And it's because, as we are seeing right now after the end of this multi-week trial, it is a bogus legal theory that three lawyers on your show right now can't figure out. So how the hell can this Manhattan jury of lay people figure this out, right? And it just shows that this is a partisan, corrupt, legally flawed, rigged process against President Trump by this corrupt Manhattan judge, Juan Merchan, whose daughter is raising millions off of this case, Matthew Colangelo, who got deployed from the Biden Justice Department, and Alvin Bragg, this Soros-funded DA who campaigned on getting Trump. This is a alleged crime 7 years ago. They brought this case to interfere perfectly in the 2024 presidential election. It sounds like if there's an election interference crime, it seems that the prosecutors are the ones who are perpetuating it.
It's being committed right now. Wait, Dave, let me ask you about a Jonathan Turley post on X. Lawyer and constitutional law professor at GW Law School in DC and also a Fox News contributor. He wrote as follows: the request for instructions is particularly interesting, meaning reread us the jury instructions. I cannot imagine a need for the instruction unless there was an early disagreement in that room on the evidence and the standards. That could indicate at least one juror who is not convinced by either Steinglass, the assistant district attorney, or Todd Blanche, Trump's lawyer, saying that this is all a no-brainer. Another intriguing possibility. One threshold issue is whether any of Michael Cohen's testimony should be considered. What if a juror invoked Judge Merchan's instruction that if Cohen lied on any material point, the jury should feel free to disregard the entirety of his testimony? That would raise whether there is corroboration, as in the Trump Tower meeting, I think he means, as well as the instruction. Obviously, this is all speculation, but it gives us something to do. That is interesting. They didn't really go to Michael Cohen. They did want some of Cohen's testimony about that meeting, but the three main requests were all about Pecker. And so what of that? Because they were told not only, if he lied on one thing, you can disregard him on everything, but they were also told that since Michael Cohen is a co-conspirator here, you can't convict Trump based on his word alone. You would need corroboration.
Correct. And that's why reading the tea leaves are so difficult. But I would agree with Professor Turley's first point that I do think perhaps there were a couple holdouts at the beginning. Just like you said, they went around the room and there were people like, and that's why they went and got this additional information. I disagree with them on the second point, because I think if Michael Cohen's credibility were the issue, they would have focused on the gotcha moment of the trial, and they did not. They didn't ask about that. That's that call involving the 14-year-old troll and whether the 96-second phone call was enough to talk to Trump about the hush money payment. So I would disagree on that second point. And just to go back to what my friend Mike Davis said, he said the three of us can't understand what the charges are. I don't want to put myself in that group. I actually understand the charges, falsification of business records leading to that second crime, that state crime. The only question I have is on appeal, will the court say that unlawful means is an element of the crime as opposed to just the means to commit the crime? Because it does need to be unanimous what the unlawful means that they exist. It just doesn't need to be unanimous on what specifically the unlawful means were.
And that leads me back to the Andy McCarthy argument that law, speaking of the unlawful means, is too vague as to be upheld under the New York State Constitution, which says you can't just incorporate all laws by reference. You have to give defendants fair notice of what they might do that would be illegal, that would get them in trouble with the criminal law. And that statute, just like doing this stuff by illegal means, by unlawful means, isn't good enough. All right, stand by. We're going to take a quick break, and there's a lot more to get to, so just, it's going to be good. Stand by. Mike and Dave, stay with us. Can your savings weather an economic storm? Think about what you've put away for the future. Inflation can render cash worthless. Real estate can crash like it did in 2008. Economies built on a mountain of debt can fall like a house of cards. There are very few physical assets you can invest in that can stand the test of time. But gold is one of them. That's why many people are flocking to it right now and why Birch Gold is busier than ever. Through a little-known tax loophole, Birch Gold lets you convert a retirement account into a tax-sheltered IRA in physical gold. And the best part is it doesn't cost you a penny out of pocket. To learn more, text MK to 989898 and claim your free info kit on gold. Again, can your IRA or 401k weather an economic storm? If not, consider looking into Birch Gold. Text MK to 989898 and explore securing your savings today.
With respect to Judge Merchan, I mean, I am like now, I have like a man crush on him. Right. He is such a great judge that it's hard to see that the jurors wouldn't have the same impression. I mean, you just keep on thinking, if you looked in a dictionary for like judicial temperament, that's what you get.
Okay, Mike Davis, that's your favorite judge. He's talking about your favorite judge. That's Andrew Weissman, former general counsel at the FBI. With a man crush. What's wrong with his man crush, Mike?
Well, this is Andrew Weissman, who was Bob Mueller's lead prosecutor for the Russian collusion hoax against President Trump, the Crossfire Hurricane bogus investigation made up with the President Obama, Biden, Hillary, the DNC. So it's actually quite amusing to watch Andrew Weissman go on MSNBC. He puts down the wine glass and goes on MSNBC and says these most outrageous partisan things that just proves that this Democrat lawfare and election interference against President Trump for the last 8 years has actually been not a conspiracy theory.
It's pretty amazing to hear him talking like that. That wasn't what Alan Dershowitz said on the show yesterday, having been in the courtroom for his excoriation of Robert Costello, the witness. As Alan put it, it was a, you looking at me? He was mad he was getting the side eye. Whatever. It's kind of beside the point at this point. The jury's got the case and we continue to await. They deliberated for about 4 hours yesterday. They're back in there. They had all the readbacks. I think they went probably back into deliberations around, I don't know, was it about 11? So now they're another hour, 40 minutes into it. It doesn't seem all that easy, whichever way they go. It seems like they are struggling with something. All right, let me shift gears because I've got to talk to you guys about the Alito story. It's been everywhere. And I want to know what you think about it. So the story is, for the audience members who haven't been paying attention, Justice Samuel Alito has a home down in the DC area, and then he has a vacation home on the Jersey Shore. Yes, same. Go Jersey. And I'm going to look for him. I didn't know he was down there. I'm going to be annoying. Anyway, so then what happened was outside of his DC area home, his wife, we now know, was flying an upside down American flag right after January 6th because Alito said, after this was reported by the New York Times breathlessly, she'd gotten into a dispute with a neighbor who was very nasty and very hardcore political. And this person wound up calling Mrs. Alito the C word and had signs on their lawn that read F Trump, but more explicitly. And she didn't like that. There were kids at a bus stop. You know, she objected to the language. Anyway, it went from bad to worse. And this was her little protest. You know, she turned the flag upside down. And the New York Times thinks he should recuse himself, as do a lot of lefties, from the J6 case that's now pending before the Supreme Court, the immunity case that is going to come out any day now on Trump. I mean, to me, that's just absurd. And then they were like, oh, it's not just that flag. At the Jersey Shore house, they were flying an Appeal to Heaven flag, which was, checks notes, on George Washington's ships during the Revolutionary War. So F Mrs. Alito and her alliance with GW. And now he needs to recuse himself because of that. So it led to something I have never seen from a justice before, because the New York Times is all over this. They've made this Jodi Kantor's full beat. For a while she did Me Too cases, and now she's on the Samuel Alito beat. He writes, it's basically F you. I'm not recusing myself from anything. He says, I understand you want me to go because you claim these two incidents created an appearance of impropriety that requires my recusal. He says, I'm going to read you excerpts. I had nothing whatsoever to do with the flying of the flag. He's talking about the upside down one in Virginia. I was not even aware of the upside down flag until it was called to my attention. As soon as I saw it, I asked my wife to take it down, but for several days, she refused. Okay, it is getting interesting. My wife and I own our Virginia home jointly. She therefore has the legal right to use the property as she sees fit. And there were no additional steps that I could have taken to have the flag taken down more promptly. All right, I'm starting to have questions that I didn't have before. My wife's reasons for flying the flag are not relevant for present purposes, but I note that she was greatly distressed at the time, due in large part to a very nasty neighborhood dispute in which I had no involvement. A house on the street displayed a sign attacking her personally, and a man who was living in the house trailed her all the way down the street, berated her in my presence using foul language, including what I regard as the vilest epithet that can be addressed to a woman. My wife's a private citizen, and she possesses the same First Amendment rights as every other American. She makes her own decisions, and I have always respected her right to do so. She has made many sacrifices to accommodate my service on the Supreme Court, including the insult of having to endure numerous loud, obscene, and personally insulting protests in front of our home that continue to this day and now threaten to escalate. As for the Appeal to Heaven flag, I had no involvement in the decision to fly that flag either. He says, my wife is fond of flying flags. I'm not. She was solely responsible for having the flagpoles put up at our residences and has flown a wide variety of them over the years. College flags, sports flags, religious flags, seasonal flags, and on. I was not familiar with the Appeal to Heaven flag when my wife flew it. She may have mentioned that it dates back to the American Revolution, and I assumed she was flying it to express a patriotic and religious message. I was not aware of any connection between the historic flag and the Stop the Steal movement, as is now alleged, FYI. And neither was my wife. She did not fly it to associate herself with that or any other group. And the use of an old historic flag by a new group does not necessarily drain that flag of all other meanings. She makes her own decisions. I honor her right to do so. Our vacation home was purchased with money she inherited from her parents and is titled in her name. It's a place away from Washington where she should be able to relax. This is so interesting. I'm so interested. Like, he went deep. He went to the legalities of ownership and control over one's wife. Like, I would have expected him to be like, bye, I'm not doing it. So what does it tell us? I'll start with you on it, Dave, that he went this far.
Me doth protest too much, right? Or he doth protest too much. I'm troubled by it, Megyn, because he's got a rap sheet. He was the one at Obama's State of the Union speech who broke custom and shook his head and said that's not true when Obama was talking about
Obama broke custom by attacking the justices personally as they did him the courtesy of showing up to his State of the Union. Wrong.
Right. But you gotta sit there and you gotta be stone-faced because you're supposed to be above politics, and he's there fighting back. And then what does he do to respond to these charges, these allegations? He goes on Fox News and gives an interview. And so you see while up here, like, man, this guy should be above politics. And the fact that he is throwing his wife under the bus for flying these flags that have been co-opted by the January 6 rioters is troubling. And look, the Supreme Court makes its own rules. They interpret their own rules. They can get away with anything. And I think that's one reason why so many people have had a loss of faith in the John Roberts Supreme Court. And John Roberts is bemoaning that fact, but look at the mirror, because it's your own justice taking these trips, not reporting them. Clarence Thomas's wife being involved with January 6th, and they do nothing about it. So that's the frustration that a lot of people on my side of the aisle are feeling.
Oh my God, Mike, I love Dave, but there was a lot wrong in what he just said there. A lot.
Yeah, I would say this, that these Supreme Court justices don't own their wives. And if anyone's ever met Martha Ann Alito or Jenny Thomas or Louise Gorsuch, I don't think that their husbands are going to be able to tell them to keep their mouth shut. They're very strong, independent women. And by the way, there's no ethical issue here requiring anyone's recusal. And if there were, why hasn't the Biden Justice Department filed a motion with the Supreme Court requesting any justice's recusal? And the reason they haven't done that is they know any such motion to recuse a justice would be legally frivolous, right? They're trying to say that the appeal to heaven flag that George Washington has flown, that Americans have flown clear across this country for centuries, including in San Francisco. The city of San Francisco flew it until Alito flew this flag, and then somehow it became a January 6th flag. Somehow that was a January 6th flag that requires Justice Alito's recusal, and somehow an American distress flag after this crazy neighbor called Martha Ann Alito the C word and had an F Trump sign in front of a school bus stop. Somehow that was a January 6th solidarity flag for Mrs. Alito. That is utter nonsense. Remember when Ruth Bader Ginsburg wore her dissent collar after President Trump was elected? I mean, there's no other explanation because they didn't even issue opinions that day from which she could have dissented. She wore her dissent collar because President Trump was elected. I don't remember seeing anyone calling for Ruth Bader Ginsburg's recusal from Trump cases. This is political garbage.
So, Dave, Alito did not go on Fox News and give an interview. Shannon Bream, who was for years the Supreme Court correspondent, called him up, and he gave her a statement about the wife having been harassed, which was totally appropriate. I mean, he spoke to Fox. He didn't speak to the New York Times. Right on. I would do the same thing. I wouldn't speak to the New York Times. They've tried to get me many times. I don't consider them honest brokers. So I get where he was coming from, and he issued a widely distributed paper statement, and then he wrote this in response to the partisans in the House and the Senate breathing down his neck. So while the left is making this up into a big thing, what they're really mad about is he had two flags outside of his houses where another person lives, who's allowed to be a partisan, by the way. She's 100% allowed to be a rabid partisan if that's what she wants. There's absolutely no prohibition against her being political or acting politically. And he points out she has the right to live here. She has the right to fly the flag. Yes, it's a little weird that he's like, she's an independent woman. And I could have done without the weird language, but fine. I'm on his side totally on his side. And what this really seems to me to be about is the left is upset that for the first time in our lifetimes, we have a conservative majority on the high court. So they do everything within their power to delegitimize them.
Well, there are also reports that this flag was flown, the upside down American flag was flown well before this incident where she was spitting on her neighbor who was calling her this ugly word. So it's a mess and it doesn't look good. And
so even if she had a stop the steal, if she had a banner that read stop the steal, that he's coming out and saying, I represent to you as a sitting Supreme Court justice. That was my wife's flag. I was not behind it. And I did ask her to take it down. That's enough. It's over. Even if Justice Alito has those thoughts privately, you can't prove it, first of all, and he has no obligation to recuse himself from a case in which he may have private feelings. The question is, can he separate himself? You don't think Ruth Bader Ginsburg had private feelings when abortion cases went up to the U.S. Supreme Court, having come from Planned Parenthood? I mean, or whatever it was, it was ACLU. My point is, he's done nothing wrong.
Well, because the Supreme Court gets to establish its own rules and interpret their own rules, he can do what he wants. It's ironic, though. He did write an opinion where he said a homeowner who flew a flag, it represents that homeowner's views. It's like right on point. And obviously, it's not going to mean he has to recuse himself from this case. But I do think when you have an appearance of impropriety, and yes, if his wife did fly the Stop the Steal flag, I would think that he should recuse himself. I do think this is one level below that, but it's enough where so many people have lost their confidence in the Supreme Court that perhaps they should step aside.
The left has lost its confidence in the Supreme Court. Mike, you used to clerk there. The left has lost its confidence because they've lost their majority. That's exactly what happened.
Yeah, and I was the chief counsel for nominations on the Senate Judiciary Committee with oversight over the federal judiciary, including ethics for the Supreme Court. Remember, with the Supreme Court, they're not interchangeable like the lower federal court judges. You can't substitute them out. There is a presumption, a strong presumption, that Supreme Court justices do not recuse on cases based upon the appearance of impropriety because they don't want people playing games to try to target conservative or liberal justices to get them to recuse on key cases like presidential immunity to flip the outcome in a case.
Mike,
That's
I only have a minute left.
The Democrats are doing here.
But Dick Durbin, Senate Judiciary Chairman, he's got the nerve to try to summon Alito and Thomas to come into the Senate to answer to, I guess, Chief Justice Dick Durbin on their alleged ethical lapses. This really does require a middle finger. I mean, like, they might actually want to send a middle finger, like a printout of one to Dick Durbin. Am I wrong?
No, you're absolutely right. Dick Durbin, the Senate Judiciary Chairman, knows better than this. I worked with him when I was there. He is being dragged around by Senator Sheldon Whitehouse, his deranged colleague, who is a partisan hack, and it is a shame that Dick Durbin is allowing this to happen. Get Whitehouse under control, Dick Durbin, you coward.
Let me tell you something, Dick Durbin. You don't control the U.S. Supreme Court. You don't control Justice Alito or Justice Thomas. And that was a hack move. That was disrespectful to the separation of powers, and he knows it. You guys are great. You're respectful and not hacks. Mike Davis, Dave Ehrenberg, always so fun. Always so fun. Wait, before I let you go, Jiffy quick, do you think we'll get a verdict today? Dave?
I think it'll come tomorrow.
Mike?
I think there's going to be a guilty verdict because this is so partisan, corrupt,
okay,
and
bye.
rigged.